Hello, everyone. I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this latest open government lesson. For those joining us for the first time, welcome. These lessons are part of a growing NEFAC library of classes on public records, open meetings, court access, and our right to record. All lessons are available to view in our FOI guide or on our YouTube channel, Five Freedoms. To everyone, please take a moment to subscribe to NEFAC's community newsletter. This is the best way to stay informed about upcoming classes and events. Just go to nefac.org/subscribe. Today's presentation is supported in part by the estate of Gloria L. Negri. Gloria was a trailblazing journalist at the Boston Globe for more than 50 years. This program is part of her legacy of newsroom education and her lifelong commitment to local journalism. You can learn more about Gloria and other supporters at nefac.org/supporters. During today's presentation, I again encourage you to introduce yourself in the chat and share your own experiences and resources. You can also use the chat or the Q&A button to ask questions of our instructor, and we'll get to as many of those questions as possible. Let's get started. Here's NEFAC president and longtime media attorney, Gregory V. Sullivan. Greg, all yours.
Thank you, Justin. As Justin said, today we're going to talk about our right to know what the government is up to, and particularly our right to photograph and record governmental proceedings and actions. I start every right to know presentation with a picture of our United States Constitution, because there are four words that stand out to me, and they are "we the people" done. Meaning we are the government. These records, these proceedings belong to us, and we have the right to photograph and record them. Again, the First Amendment, which gives us free speech and free press and petition and assembly and religion rights, are heavily intertwined with the topic we're discussing today. And I always point out that without the right to know what the government is up to, our rights to free speech and free press are limited or eviscerated even. Here in New Hampshire, we're lucky to have a Constitution with Part 1, Article 8 and Part 1, Article 22, which mandates and explains that all governmental actors are our substitutes and agents and must be accountable to the people. Government must be open, accessible, accountable, and responsive. And our access to records and proceedings must not be unreasonably restricted. And again, in New Hampshire, our Constitution guarantees free speech and free press in stronger terms than even the First Amendment. We only have 30 minutes, and there's a lot to talk about. That reminds me, I've got to hurry up. Today, we're going to talk about the right to photograph and record public proceedings, the right to photograph and record court proceedings. It's important to remember in this field that New Hampshire's right to know statute 91A does not apply to courts. We're going to talk about the right to record and photograph records, including court documents, the right to record and photograph within and without public buildings. Without the public building is the easy one. The photographing within, as we'll see, is the difficult one. And I've been asked to comment on public officials' right to privacy. Right off the bat, in Chapter 91A, we have the right, with respect to all public meetings, to record, tape record, photograph with cameras, videotape all such meetings. It starts off subject to the provisions of 91A3. 91A3 is non-public meetings where we don't have the right to be there, never mind record. So I want to point out, when I say public proceedings, it's not just the school committee meeting or the town council. It's also government officials acting within the scope of their duties inside and outside public buildings. For the first time in 2011, the First Circuit Court of Appeals in Boston ruled that Mr. Glick was within his clearly established First Amendment rights to film police officers effectuating an arrest on the Boston Common. It is a basic, vital, and well-established liberty guaranteed by the First Amendment. Now, that was established in 2011 because Mr. Glick was arrested by Boston police officers merely for photographing their conduct during an arrest. Here in New Hampshire, 3 years later, Carla Gericka again was arrested for filming a police officer during a traffic stop. And the court ruled her First Amendment rights were clearly established at the time of that stop and arrest. And she, again, had every right in the world to be photographing. The picture below just demonstrates, and we're going to talk about privacy momentarily, but in order to have a reasonable expectation of privacy, and this goes for police officers and government officials, in order to have an invasion, a wrongful invasion of privacy, we must first have a reasonable expectation of privacy. Court records, the Supreme Court in New Hampshire has made it abundantly clear that we, the people, have the right to access court records. However, like the rights to free speech and free press, that right is not absolute. There are privacy interests, for example, that may warrant the non-disclosure of certain court records. There's a balancing test that the courts apply, and they apply it on a case-by-case basis. Associated Press versus State, for the first time, gave the citizens of New Hampshire the right, and in that case through a media representative, to film what was going on in our courtrooms. We still don't have that right on the federal court level. But in New Hampshire, we now have rules, and this happens to be the Superior Court rule, but it's pretty much mirrored in all the courts and court levels in New Hampshire. What I'm not crazy about, as you'll see, I've highlighted in yellow, it says that anybody, whether you're a member of a media organization or not, shall be permitted to photograph, record, and broadcast all court proceedings that are open to the public, provided that such person provides advance notice to the presiding justice in accordance with Section C of this rule, that he or she intends to do so. And that gives people who object to the recording or the broadcasting notice, and the court can conduct a hearing to determine whether or not photographing and recording will be allowed. But again, paragraph C of that same rule says that you must submit a written request to the clerk of court, who in turn shall deliver the request to the judge before the proceeding has commenced, or if it's ongoing, at the first reasonable opportunity. A lot of times the public and the reporters of news organizations aren't aware of a court proceeding and till they hear about it subsequent, usually to an arrest. Civil proceedings are more regularly scheduled, and people who are interested can check the docket on a day-to-day or week-to-week basis. So it's not that difficult to file. As you can see, this is the form designated by the court should you wish to film in the courtroom, and you can see that it addresses the Supreme Court rule, the Superior Court rule, the Circuit Court rule, probate court, and the family division. Just date and sign it, put in your name, your organization, if applicable, because we will see, I think in the next slide, yes, that the presiding justice can indeed give greater access to what the rule calls the established media organizations who disseminate information concerning court proceedings to the public. And the court can also require representatives of the media to arrange for pool coverage. Pool coverage means, for example, there will only be one camera recording in the courtroom, but there must be a feed to all the other news organizations at some room in the courthouse. All documents and exhibits filed in the court and not sealed must be available for inspection by members of the public. And of course, when we say inspection, we mean the right to photograph as well as request copies. One of the topics I've been asked to speak about today, the right to record and photograph within and without public buildings. And again, as I've said, if you're outside anywhere, you have the right to film and photograph pretty much everything you can see on a 360-degree view. And that includes, of course, all public buildings. There may be, for example, areas of a public safety building that the government has legitimate reasons, I can't imagine what they are, to not allow photographing of that area. But as a general rule, yes, we can photograph outside public buildings. The rubber hits the road, however, when we try to photograph within. There's a fellow named Abrams, and I believe this was just recently. He walked into a town hall, I believe it was Warner, New Hampshire, and was photographing or recording, rather, the town administrator. She asked if he was recording her. He said yes. She said, no, stop doing that. He said, no, I have every right to film you. You're a public official performing your official duties. She called the police. The police came, asked him to stop recording. He indicated that he had every right under the First Amendment to record, but he made the mistake of stepping outside to make a phone call, maybe to his lawyer, I don't know. But when he turned around to go back in the town hall, he was met with a sign, "Town hall is closed today." Now, this is after he had been in there for a period of time. So with respect to photographing and recording, what are the reasonable limits that courts and law enforcement can impose? And we start with a basic premise that for someone to claim they have been invaded wrongfully in their privacy, they must first enjoy a reasonable expectation of privacy. That word reasonable pretty much, to me, underlies all law. There are only 4 kinds of invasion of privacy, wrongful invasion of privacy, recognized by the law. And they're pretty self-explanatory. Intrusion upon seclusion. You can see in the image in the upper right-hand corner what we're talking about. Because I generally tell people once they exit the front door of their home, and this is only if the front door is closed, they no longer have a reasonable expectation of privacy. Now, there are instances where the expectation of privacy is reasonable. For example, a changing room in a department store, a bathroom stall, anywhere. But if the intrusion would be highly offensive to a reasonable person, that person whose privacy has been invaded has the right to bring a valid action in court for wrongful invasion of privacy. Second area of wrongful invasion of privacy, publicity given to private life. And this is the one that ends up in the courtroom the most, where the disclosure of facts that are publicized is highly offensive to a reasonable person and is not a legitimate concern to the public. I give the example of the newspaper photographer walking down the sidewalk on Saturday night, where he has a right to be, going by the home of the principal of the local elementary school. He notices that the front door is open. There's a storm door closed, but it's made of glass he can see through and he can photograph. And he notices that the principal and her husband are both nude and they're fist fighting. And oddly enough, the living room is full of empty beer cans up to their kneecaps. So he takes a picture, brings it back to the newsroom, and the question becomes, when he wants to tell the editor to put it on the front page of the Sunday paper, the editor says, yeah, but that's going to be offensive to that principal. And the photographer says, yeah, but don't you think it's a legitimate concern to the public? And again, every case turns on its own set of facts. This is the balancing test that courts talk about. False light invasion of privacy, I'm going to be dealing with the rest of the slides with rapidity due to a time limit. There's a fellow named Warren Spahn. He was the best pitcher in baseball in the late 1930s, the early 1940s. He gave up his baseball career. He went to Belgium and fought in the U.S. Army. He was wounded, ultimately came back when the war was over and started playing baseball again. Someone thought it was great fodder for a book. They wrote a book about Warren Spahn saying what a hero he is, that he was wounded in the battlefield, taken away on a stretcher in an ambulance. Those facts were false. And Warren Spahn was embarrassed when people were asking him about questions about his military service. He brought suit and was able to have all the books destroyed, and he was awarded money. The difference between false light invasion of privacy and defamation is that false light invasion of privacy can enhance your reputation, whereas defamation has to damage your reputation, but false light invasion of privacy can lead to damages for the plaintiff. Offensive to him, and this is the actual malice standard. The person who publishes knew that it was false and published anyway, or acted with a reckless disregard for the truth. The last type of invasion of privacy, appropriation of name or likeness. Some of you may know who Johnny Carson was. He was the host of The Tonight Show. Every night his show would begin with his sidekick saying, "Here's Johnny." A fellow in Boston decided to name his portable toilet company, "Here's Johnny." Johnny Carson successfully sued. So I am going to just take a step back and talk a little bit about why we have the right, how we get the right to record and photograph these proceedings in New Hampshire. We have 91A, which applies to all public business, not the courts and not the legislature, but town hall, city hall. So it's essential, this openness to our democracy. So the chapter gives us citizens the greatest possible public access to the actions, discussions, and records of all public bodies and their accountability to the people. Government records, pretty much anything that a government official obtains, information, knowledge, opinions, facts, data of any kind. This is all statutory. We have the right to inspect and to copy. And by copying, I mean photographing all public records. And these records have to be available to us during regular business hours, and we have the right to inspect and copy. Copy means photography, photostatic copy, printing, or electronic or tape recording. We have the right.
Greg, I'd like to jump in with a few questions before you continue. If we could go back to the right to film within public buildings. Question for you: are all public buildings considered the same? So, for example, do we have the same right to go into a town hall and begin recording in the public areas as we do going into the lobby of an elementary school during a school day?
Schools, prisons, jails, police stations are not on the same level as your town hall, for example. We talked about some of the reasons that access to buildings and records can be denied, and public safety was number 2 on the list, national security number 1, but really in dealing with local and state governments, it's the public safety exemption. So no, not all government buildings are treated the same for First Amendment access purposes.
And within those buildings that are provided to us that are accessible, that we can record in, are all areas within those buildings treated the same? So for example, say we went into a post office, for example, public building, we go in, we start recording. Is everything fair game as far as what we can record, or are we just limited to certain areas where the public has assembled? Can we record anything that's in plain sight, even though it's over the counter? Are there lines there that you could draw for us?
You can photograph and record anything within your sight so long as you are where you have a right to be. So the right to record and photograph in buildings like the post office, to me, differs not from the right to be there. In other words, we don't have the right to go over the counter or go in the back room without permission of, someone in the post office. Same thing for a police station. But if we are where we have a right to be, I say we have a right to photograph and record, absent some public safety consideration that's valid and legitimate.
Understood. And one final question in this line. Do we have the right to film everyone within those areas, everyone that we can see? And I know you went over a number of privacy interests, so there certainly could be some question as to how you use those recordings, but the recording itself, say there's underage individuals, minors in the vicinity, can we record them along with the adults, or should we be taking, or do we have to take certain precautions not to record certain individuals that are underage or may not want to be recorded in the first place?
No restrictions of that nature. Just think about walking down the sidewalk of a busy city or town. You have the right to record. Parents and their minor children have no reasonable expectation of privacy once they leave their front door. So, think of the baseball game, the crowd, minors, adults, doesn't matter. If we are where we have a right to be, we can record.
Appreciate everybody who joined us today. Really grateful for your time. As a reminder, we provide these lessons as a public service to you. So please return the favor and encourage your colleagues and friends to join us for future classes. And we have many. You can find a listing at NEFAC.org. You can also consider making a donation or becoming a sustaining member at NEFAC.org/support. On behalf of NEFAC, many thanks again, and we'll see you all next time. Take care, everybody.